委員就今日就係
Good afternoon. So this is the sixth meeting of the Bills Committee on the Employment Amendment Bill 2014. Now, because of what happened on Friday, I want to say something. I want to say very clearly how I intend to conduct meetings. I will not end filibustering. I'll allow members sufficient time to ask questions. But then concerning the following 4 items, please do not raise them again. This is because the administration has given replies on many occasions. First of all, wages for paternity leave, 4/5. This has been discussed for 8 to 10 times. And then the proposed increase of the number of paternity leave days from 3 to 7 days. Again, this has been discussed many times. Third, now, if an employed person gives notice to take paternity leave, then what is the employee protection? And again, the administration has given the same reply many times. And then fourthly, concerning how to prove that the employee is the father of a baby born in the mainland. So these are the 4 issues that have been discussed and raised time and again. So it's true that last time we started clause by clause scrutiny, but I can still allow each member 4 minutes to raise policy issues, and then we'll continue clause by clause scrutiny at about 5 p.m. So each member will have 4 minutes. Mr. Lee Chuk Yan. Thank you, Chairman. In fact, almost all the policy issues have been raised and discussed, as you've rightly pointed out, Chairman. And I think we've come to a point when we need to decide how we should proceed and deal with this bill. Now, judging from the present situation, it will be quite impossible for us to resume second reading on the 9th of July. In other words, resumption of second reading can only take place in October. And the administration has told us that if we have comments or suggestions, those will be brought back to the LAB for discussion. And you've mentioned 4 items, Chairman. The last one is rather technical, involving the mainland, and in fact I've also raised an issue concerning no less than 3 days rather. So I want to know whether the administration will take our suggestions back to the LAB during the summer holidays, so that when we resume in October, the LAB will have discussed our suggestions and comments. And I want to say that, in fact, I've said this many times already. I don't want to repeat this point again and again. And that is, I don't want the administration to hold electrical members under threat, always referring to the LAB. The administration, please. In fact, we are not dragging our feet, Chairman. So we'll wait till the Bills Committee has completed its work, and then we will decide on the way forward. And if members want to propose CSAs, then I will not rule out the possibility of going to the LAB during the summer holidays. And I think I can tell the administration very clearly that I will be moving amendments. First of all, from 3 days to 5 or 7 days, and second, from 4/5 pay to full pay. And in order that I can get the President's consent, I may have to consider proposing 5 days, because if I propose a CSA of 5 days, then there may not be any charging effect. But then if I propose 7 days, there may be public fund implications. So, Chairman, So it seems that they are saying that they will consult the LAB only after this committee has completed its work. But I, in fact, want to tell Mr. Hui that I will definitely be moving CSA. So will he consult the LAB as soon as possible. I think we have to be clear about members' views. And now, so today, Mr. Lee Chuk-yan has told us that he may move an amendment to increase the number of paternity leave days to 5. So we have to be clear about members' amendments before we go back to the LAB. Chairman, I have got some seconds left. And so, Chairman, can I ask you this question? Can we set aside some time to discuss CSAs, members' CSAs? The next meeting will be held in the morning on the 8th of July. So if you have CSAs to propose, please give them to the Secretariat before the 8th of July. Now, I think resumption of second reading can only take place in October. It's impossible to have the resumption of second reading within this session. Mr. Jeffrey Lam, Chairman, right at the outset, you mentioned the meeting last Friday, and you raised a lot of questions concerning the rules of procedure. So I don't know whether you are worried that we may make use of points of order, rules of procedure to carry out filibustering. We will not do that. So, of course, we do have our views concerning paternity leave and paternity leave pay, but we'll not make use of these dirty tactics, so to speak, to delay the handling of the bill. Now, if members have CSAs to propose, then is it that those CSAs or suggestions will be brought to the LAB for discussion first, or what will the procedures be? Now, in fact, all members can propose CSAs. And of course, you can ask me, the chairman of the Bills Committee, to move the CSAs on your behalf. But of course, if this is to happen, we must have the motion passed in this Bills Committee. Now, Chairman, what I mean is this. Now, if a member proposes CSAs in this Bills Committee, is it that the administration will go to the LAB first and then come back? Or is it that the CSAs will be dealt with and passed first and then the administration will go to the LAB? Now, let me clarify. The LAB procedure is not part of the electrical procedure, but the administration has been telling us that it must consult the LAB. But of course, we do respect the administration's position. Mr. Hui, can you elaborate? Now, if members propose CSAs in the Bills Committee, then after the Bills Committee has completed its work, then we'll need to consider whether we need to go back to the LAB. So it's for the administration to decide whether they need to go back to LAB. I want to say that consulting the LAB is not part of our legislative procedure, but it so happens that this is the Employment Amendment Bill 2014, and as a result, the administration thinks that it is advisable to consult the LAB. Mr. Kwok Wai-Keung, Chairman, you were proud to say that you would allow us ample time to ask questions, but then I think you need to appreciate the cooperative attitude of members. So I think you should be proud of us. We should be proud of ourselves. We didn't spend 30 hours raising points of order. So In fact, the FTU hopes that the number of paternity leave days can be more than 3. Of course, employees want a better deal. Now, but then it seems that members may want to move CSAs, and as a result, the administration will have to go back to LAB during the summer holidays. But then our employees in Hong Kong want to know when the bill can be passed, when employees can get paternity leave. And is there a possibility that we may not be able to resume second reading when the next session begins in October? So can you tell us the worst case scenario? And in fact, someone has said before that the administration may wish to withdraw the bill altogether. I want to say that employees in Hong Kong are very concerned, and if you know, for paternity leave, it can't be dated back, that there's no retrospective effect. So we want to know when employees will be able to enjoy paternity leave. Mr. Hui, I can't say for sure how long the consultation process will last or will take. But then, as I said at the beginning, we also want to see the early resumption of second reading and the early passage of the bill. But then, of course, if the consultation process takes more time than expected, then resumption of second reading may have to be delayed a bit. So I can't tell you at this stage how much time we need for consultation. All right, that's all. Mr. Kwok, Ms. Chen Yun Han. Chairman, thank you. Chairman, whether you agree or not, we may need to keep repeating our standpoints or viewpoints. I've got this question, Chairman. In fact, we are at the same time scrutinizing other bills.
So, Mr. Hui, regarding the amendment of the employment ordinance, is it the case that if we propose any amendments, you will take it back and not accept it? As I said, if the amendments are technical in nature and it doesn't involve the consensus arrived at by the LAB, that may not be necessary. For the bills, the different bills that we have submitted, we had a similar situation. For minor amendments, the government may move them. So we may not need to consult the LAB. But if the amendment involves the number of paternity days for paternity leave, then we may need to consult the LAB because it involved the consensus arrived at earlier by the LAB. Mr. Hui, would you agree that the government is threatening LegCo by the attitude you adopt? If you say we were proposing amending the number of days from 2 to 5 days, so say you need to go back to the LAB. By doing so, would you agree that you are threatening LegCo? It's not the first time that they are threatening this council. Definitely, we're not threatening members of the council. For this procedure, it doesn't mean that after we've gone to the LAB, we won't come back. In the past, after we've heard views of LegCo members, sometimes we incorporate those views. That is, we go back and consult the LAB, and if the LAB consults, agrees, then the government will move an amendment accordingly. I think we've had precedents in the past. For example, the bankruptcy ordinance and the statutory minimum wage ordinance, it was the same. But this time, if the amendment involved the core major part of the LAB consensus, then we'll have to go back and consult the LAB and see whether or not their members agree with the proposals made by members. So there's no question of our threatening this council. But the objective reality is that you're doing that. I mean, we don't have very much time left, and I'm sure some of our colleagues will be moving amendments. All of us have been. We know that the LAB is an advisory body, and for proposals which are controversial, we would support them. But in the past, in the course of scrutinizing any bill, we would be moving some amendments. But now the government is saying that if we're going to make a major amendment, you will go back to the LAB. Doesn't mean that the bill will not be passed. So I mean that is tantamount to threatening members of this council. If that's the attitude of government, I would like to know which official had said this. Is it the secretary or the financial secretary or Mr. He yourself? Thank you. I think that is the position of the government. It has always been the position of the administration. That I said that this happened in the case of the statutory minimum wage ordinance and also the bankruptcy ordinance. If an amendment requires us to consult the LAB to see whether the government can accept such a proposed amendment, I mean, this is not unique to this bill. Ms. Chen. Okay, you can wait for your second round. Ms. Chen. Of course, all members would like to fight for as many number of paternity leave days as possible. If 3 is not enough, you say that you want to increase it to 5, 7, even 14 days, or you can even extend it to to be equal to the number of maternity leave. But I think on this particular paternity issue, this has been subject to lengthy discussion by the LAB, and basically, the consensus is that 3 days are acceptable. Now that the bill is submitted to this council, and finally we are able to set a paternity leave for those who are about to become fathers. So I think we should do this expeditiously. Instead of saying, "Oh, we don't like it, I want to delay it for for another term or two," then we don't know when this will materialize. So my question is this: if the bill could be passed before the summer recess, when are we going to be able to implement the 3-day paternity leave? Well, I've already said that we will not be able to resume the second reading before the summer recess. Well, in that case, Chairman, is it your estimate or Mr. He's estimate that this will not happen before the summer break? No, I think we have discussed this earlier. I think we can only have the resumption of the second debate in October. Okay, so we're talking about October. But I think we still need to clarify the issue at stake. Mr. Hui, suppose the bill were enacted in October, and then the employees will be entitled to paternity leave, and then 2 years later, if the reaction of the public and if the LAB thinks that we can increase the number of paternity leave days, is there a restriction regarding the time during which we cannot propose another amendment? Or is it the case that we can come back a year later and move another amendment? Mr. Hui, regarding the bill, there is no restriction as to that is how long before you will be allowed. We can move another bill proposing new amendments. But in the LAB, when it discussed the question of paternity leave, it was the consensus that there should be 3 days of paternity leave for employees, and the LAB also said that 1 year after the implementation of the new legislation, there will be a review. So that will be an opportunity to review how the new legislation operates. Next. Chairman, I don't know my understanding is correct. The Bills Committee still has another meeting scheduled for the 8th of July. So if members wish to move any amendments, I I think the administration would have heard all the views expressed by members and take it back to the LAB. And if the LAB accepts any of our new proposals, then we can have some new amendments in October. You said that the LAB has already arrived at a consensus. And of course, it would be very difficult if we were to deviate from that consensus. But when you go back and consult the LAB, and if you decide to stick to the same proposal, does it mean that you'll not come back to us, or will you still, come back to us? I do not recall that in the past that when the LAB fails to arrive at a consensus, then we wouldn't resume the second reading. I think we will follow the previous practice, that is, we'll consult the LAB. We hope that after the consultation, we can come back and resume the second reading as soon as possible. Any other members who would like to ask questions for the first round? No? Ms. Chen Yun Han, 3 minutes. Thank you. Mr. Hui, according to your answer to Mr. Pan's question, you're saying that it's not because members of the committee move an amendment, then you would need to go back to the LB. If that's not the case, if that's not the case, we have another meeting scheduled for July. I'm sure the LB will meet in the summer vacation, and I hope you will come back to us punctually by October. I think after we've discussed all the principles, we'll discuss the details, and normally we should be enacted voted in November. But Mr. Hui, could you tell us clearly whether it is the case that since members are saying that they will be moving amendments, and you say you want to go back to LAB, whether LAB accepts our proposed amendment or not, will you come back to us in October so that we can go through the scrutiny, and then the matter, the proposal can be voted in November? Is that the case, Mr. Hui? Instead of saying that if we have any amendments, you withdraw the bill. What you did last time was tantamount to threatening this council. I must clarify that after we've consulted LB, we will withdraw the bill. I think, according to the record, I've never said that. And secondly, regarding the timing for consulting the LAB, I cannot tell you how much time it would take. According to previous experience and based on other proposals, when we consult members of the LAB, the members of LAB represent their respective business chambers or trade unions. So when we consult the members of the LAB, these members may need to consult the business chambers, the unions they represent. So it's not just the case that after the LAB has met, the matter could be decided, because the members may need to go back and consult, their own chambers or trade unions. I agree. You need to allow them to go back and consult the organizations they represent. We're going to have a meeting in early July, and then you still have 2 more months after that. So I think there should be sufficient time for members of the LAB to consult the respective organizations. So could you clearly tell us you will come back to us in October, so that and then we can go to the council and put this to the vote? Would you agree? Do you agree that you'll come back to us in October? Thank you. We hope to be able to resume the second reading as soon as possible, but we cannot promise that we'll definitely be able to do that in October. So the answer is as soon as possible. Okay, you want to go for the third round? Mr. Tenkapil, it's your first round, so I'll give you 4 minutes. I'd like to follow up on Ms. Chen's question. I understand that the LAB does not have regular meeting days. Roughly, it meets once every 2 months. For issues you would like the LAB to arrive at a consensus, you will proactively, ask them to arrange a meeting. But I think the LAB can certainly, have several rounds of discussions and resolve the whole matter. If no agreement could be made, then it can draw a line, and then we can go back to the original proposal. Mr. Hui, could you tell us whether the LAB can meet 5 times in a week? Thank you. Well, as I said, LAB members do not just represent themselves. In the course of its discussion, they may need to go back to the chambers of commerce or unions they represent and consult their members. And such consultation may not be able to finish within a day or two or a week or so. So even if LB were to meet 5 days in a week, it may not really help. So in the course of the consultation, it will also depend on the nature of the amendment, whether or not it's acceptable to them, and whether or not there are alternative options, and so on. So at this stage, I cannot, give you a definitive answer, because we haven't even started the consultation, and we don't know yet what amendments members of the Bills Committee will move. Whatever amendments and so on, I think we've already, stated them clearly already. So when the LAB meets, if I am an LB member, I represent the business sector. I heard that the business chairman say that it would be best we don't have any paternity leave at all. Then I would tell the government, some political party ask for 5 days, other parties ask for 7 days, and why don't you conduct an extensive consultation, conduct a cost and benefit analysis, and come back after a year. If that's the requirement they made to you, what would you do? With so many, if you assume that that's the reaction of the Chamber of Commerce or trade unions, I don't think I can answer those hypothetical questions. No. All these assumptions is based on the fact that they want to delay the commencement of the bill, because the longer they wait, the less they have to pay. So what would you do in that case? As I said at the beginning, the administration would like to resume the second reading as soon as possible. We don't want to delay the commencement of this bill. But we can't tell you how long the consultation would take, but we hope we will be able to do so as soon as possible.
Yes, you can continue. I understand that the present term of the LAB will end at the end of this year. So I want to know whether this matter or this issue is going to go beyond this present term of the LAB. Now, it is not mandatory for issues to be resolved and decided on within at the same term of the LAB. Sometimes the issues may straddle 2 terms. So I really don't know whether we will be able to get paternity leave for our employees in Hong Kong. Ms. Chen Yun Han, the third round, 2 minutes. Yes, Chairman. Mr. Hui, please be more decisive. No, what is before us represents a consensus reached by the LAB in the last term. Some members may wish to move CSAs, and I think you should go back to the LAB on the new proposals. For example, 4/5 versus full pay, or 5 days. Because there was a consensus reached within the last term of the LAB. So please do not put forward excuses. Please do not drag your feet. And I think after you've gone back to the LAB, then the CSAs will be voted on by electrical members. Mr. Hui, I want to say that the LAB held a few meetings and came to the consensus of 3 days. I don't want to interrupt you, but I only have a limited time. Mr. Hui. Now, yes, you can consult the LAB, but then you can decide what you want to do. You should be clear about your role. You can make a decision. I want to go on asking questions. Yes, you can. You can have a 4th round, a 5th round, and even a 6th round. Yes, I will, because I really am very angry, and I have lots of questions and comments. All right. 3rd round. Any member? No. 4th round. How many minutes? 2 minutes. I think 1 minute is irrational and unreasonable. It's impossible to ask questions and get replies within 1 minute. Of course, I would prefer 3 minutes, but I respect your ruling, Chairman. So, Mr. Hui, is it that you will come back to us in October, and you may decide not to change anything, and then we will deal with our own amendments. So please do not drag your feet. Can you tell us or promise us that you'll come back in October, Mr. Hui? Now, we never set deadlines for LAB discussions. But Mr. Hui, say for the special stamp duty, we are told that there are deadlines, and in fact, a consensus was reached in the last term. So the administration should not keep dragging its feet. Now, I don't think next time we should still ask Mr. Hui to come. Ask the secretary to come. Mr. Hui. Mr. Hui, do you have anything to say in response? Chairman, I've promised to come back to electrical as soon as possible, but I can't say here how long the consultation with the LAB will take. I think we should invite the secretary to come to our meeting in July. Mr. Hui, that's because you simply can't make a decision. So I want to ask the secretary whether he is dragging his feet. I want to ask the secretary whether he wants to refrain from doing anything, despite the very tense relationship between employers and employees. So it seems that Mr. Hui keeps saying that there is no deadline, there is no timetable, and after 4 rounds of questions, Mr. Hui is giving the same reply. No deadline, no timetable. All right, 3 minutes, Ms. Chang, 2nd round. Mr. Hui, Chairman. Now, if members don't have any CSAs, and if the bill can resume, or if we can resume 2nd reading in October, then when can the bill commence the earliest? Even after the passage of the bill, we'll have to make subsidiary legislation for the formal commencement of the bill, and that's going to take 7 weeks. So in other words, 1st of January next year, right? Is that right? I have to count the days. But I want to say that after the passage of the bill, we'll have to make subsidiary legislation for the formal commencement of the bill, and that's going to take 7 weeks. But assuming that major CSAs are proposed, for example, increasing the number of leave days from 3 to 7, then of course you need to go back to LAB. And if that happens, when can we have the resumption of second reading then? Let him give his reply again, Ms. Chang. The administration hopes to come back as soon as possible. All right, let me put my question in another way. So concerning the 3 days paternity leave, this idea of 3 days, how long did the LAB take to come to a consensus? The discussion started in April 2012, and then in November 2012, the LAB came to a consensus on 3 days. So how long? A year or two? 6 to 7 months. So you started consulting them in 2012, and they reached a consensus in November 2012. All right, November 2012. But before that, had you talked to the LAB on the idea of paternity leave? In April 2012, we put the package or the idea to the LAB. So the LAB may take 6 months to reach a consensus, or it may never be able to reach a consensus. Is that right? Mr. Hui, in some cases, on some issues, the LAB needs a longer period of time to reach a consensus. So if there is an absence of a consensus, then I'll let Mr. Tan Ka-Biu ask first. We'll come back to you later, Ms. Chang. I want to know about the role of this committee. Now, some members have said that they will move amendments, and in fact non-BC members may also wish to move amendments. Say when we go to HC, and when we have an idea as to when resumption of second reading takes place, then non-BC members may also wish to move amendments. So when will you be dealing with those? Now, of course, I'll allow members to discuss policy issues thoroughly. You can speak for 10 rounds or more today. It doesn't matter. Now, of course, I hope to finish clause-by-clause scrutiny before the end of this session. But then that's only my timetable. That's only my plan. And whether my timetable can materialize depends on whether members have got questions to ask. Now, I have already said that on 4 issues, I will not allow further questions because the administration has been giving the same reply every time. So, of course, Bills Committee members as well as non-Bills Committee members can propose CSAs. But my timetable remains that we aim to complete clause-by-clause scrutiny on the 8th of July. Legal advisor, do you have anything to add? Thank you, Chairman. Concerning the amendments, the CSAs, of course, we hope that members can, as far as possible, propose them before the 8th of July so that there can be a discussion in the Bills Committee. And of course, non-BC members are also entitled to move amendments. Mr. Ho, I also want to be able to move on to the next stage as soon as possible. So after we've completed our scrutiny, you go to the LAB, and then we may think we may be able to resume second reading in October or November. But then what if at that time non-bills committee members move certain amendments, and you have to go back to LAB again? And that may take another few months. It depends on whether that CSA was one that or is one that we've never heard of, and if it's of key importance, then I really cannot rule the possibility of having to go to LAB again. But I believe all the important issues have already been covered by this Bills Committee. So even if non-Bills Committee members move amendments, at that time we will not have to go back to LAB again. Second round, Mr. Lee Chuk Yan. Now, do you know what the crux of the problem is? The government, the administration is trying to threaten this council with LAB, and of course we are worried, we are afraid. We don't know whether you will come back, whether you will ever come back, and I can admit that we are worried, we are frightened. That is because the administration does things in a despicable manner. We know that the LAB or the LAB's consensus is 3 days. And if we move a CSA, then you may want to go back to LAB again. I think what's important is whether members support the CSAs, whether the CSAs can get majority support in this council. In fact, the administration seems to put the LAB over and above the LegCo. Mr. Hui said that the LAB would be consulted during the summer holidays. In my view, there is no need to do so. But if you really want to consult the LAB, all right, but please come back as soon as possible. But then Mr. Tam Kapiu asked whether you would have to go back to LAB again if another CSA was proposed in October or November. And we are we are of course worried. We are really worried.
Ms. Chang said that this may go on forever. So I think you may, well, the AB doesn't arrive at a consensus on every issue, and you can't just wait until the AB arrive at a consensus before you come back to us. Is the 3-day, paternity leave is a consensus? If not, then that is the consensus. In answering, I think you should answer Ms. Chang's question. You didn't have the opportunity to answer her question. That is, what happens if there's no consensus? All right. After the LAB has deliberated, you come back to us and say there is no consensus. Mr. Hui, in the past, when we adopt the same approach in respect of other employment ordinances, don't ever think that we are trying to threaten the Legislative Council. Now, if we've consulted LAB and if the LAB agrees, then the government will move the amendment. This has happened in the past in respect of the statutory minimum wage ordinance and the bankruptcy ordinance. We want to, listen to views of members, and if we could arrive at a consensus, then we will move an amendment. Ms. Anne Chang, your third round, 2 minutes. Chairman, I don't think the administration of Mr. Hui is threatening us. Looking at Mr. Hui, I can see that he's a gentleman. I don't think he would threaten us. If we place him, he sit next to Ms. Lee Chee-yang, we wouldn't know who is the one who would, threaten us. But this time, you must understand that if the government has the resources and still is unwilling to provide the welfare, then of course we should force the government to do it. Paternity leave It's something between the employer and employee. It's a question whether or not the employer is willing to come up with the money, or whether or not the employer is willing to allow 3 days paternity leave to its employees. When the government consulted them on the bill in 2012, but we all know that many years ago, Ms. Chen Yinhan of the Federal Trade Union had been fighting for paternity leave for employees, and there's been a lot of discussion. Of course, Mr. Lee Cheuk-yen's union had also raised the same issue. Now that we have so many rounds of discussion and eventually we have this proposal before us. So, Chairman, I think we should implement this as soon as possible. And furthermore, there will be a review 1 year afterwards. So if there's a need, if need be, we can have another discussion. At least employees will get 3 days of paternity leave. And then we don't have the representatives of the business people present. Of course, if they come back suddenly, they will be raising issues. But at least I think if after the LB has deliberated, then at least the employees will get the 3-day paternity leave yet. So I hope members will support the 3-day proposal first. Mr. Chen Chi-kun, your first round, 4 minutes. I would urge members not to accept the 3-day package first, because in the case of universal suffrage, it's not a question Mr. He is threatening us, but rather the system allows the government to make use of the mechanism to oppress LegCo. That is, if members move any amendments, then they will take it back and delay it for a few months, and they will see whether or not members are willing to pay that price. Regarding the amendment, I'd like to ask a more detailed question. Let's say if members have proposed 3 days and 5 days and 7 days paternity leave, and the government said you don't want to take this back to LB. What do you mean by that? Or is it a question whether or not we accept 3, 5, or 7 days, or are you going to take this chance and see whether or not their bill will be vetoed or passed in LegCo? Or is it the case that so if somebody proposed that paternity leave should be 1 month, obviously you won't arrive at a consensus. So if a member gave pre-warning that he will be moving an amendment, how are you going to deal with that? And secondly, another member asked that you cannot, if you find the amendments acceptable, you'll come back to us. But what happened at the next stage? There would be yet other amendments moved by members. You said that most of the views have already been expressed. But if somebody really want to cause trouble and want to delay this whole exercise, then they can move one amendment at a time. So when you go back to the LB, do you need to wait until we have all the amendments ready before you go back to the LAB? Or is it that even if there's no amendment, if you search the views of members, you still go back and consult the LAB? Will you have such a detailed discussion with the LAB? Thank you. For amendments moved by members, I definitely will consult the LAB. But if there are other views which we believe are important, we'll certainly talk to the LAB. Of course, we do not necessarily have to consult the LAB, especially on technical issues. So we'll focus. So if there are any amendments moved by members, we will focus our discussion on the amendments. So if it's 5 or 7 days, will you seriously consult the LB whether to accept that? But if somebody suggests that the paternity leave should be for a month, how are you going to deal with that amendment when you go back to the LAB? Well, I'm just imagining that if the LAB can accept 7-day paternity leave and somebody proposes 1 month, and the LAB, no. We all know that it will not be, supported. But how would the LAB discuss that? Would you assess the possibility of the amendment chance of being, passed? Because if somebody wants to delay the whole exercise, they can propose a 2-week paternity leave, and then the whole thing will be delayed. Other than this committee moving amendment now, there is another opportunity That is, before we resume the second reading, then other members may also move amendments. So my understanding is that before the resumption of second debate, if somebody move an amendment that we've never heard of before, then, and if that should happen, then, and if we think that it is really necessary, we may need to go back to the LB. What I'm saying that if someone proposed a paternity leave for a month, Mr. Chen Chichun, I think you have to wait for your second round. I'll ask our legal advisor to clarify whether or not there are only 2 occasions for members and non-members of this Bills Committee to move amendments. Thank you. Regarding the amendment bill, after the administration has served notice for the resumption of the second reading, then members will need to move their amendments before that deadline. Thank you. Ms. Chen Yun Han, your 5th round. Again, you have 2 minutes. Thank you. I think this is a question for both the chairman and Mr. Hui. According to your proposed arrangement, I basically support your proposed timetable. Your estimate is that we would have finished asking all the questions we want to ask by July. And I think we've already started the clause by clause, except that this time we're allowing more time for members to ask questions. All right? After we've relayed our amendments to Mr. Hui, I don't think you should give the impression that you're using the LAB to hold this council hostage. Otherwise, the next time we can ask the secretary to see whether or not they really want to threaten us. Even though there is a consensus, you still want to delay this. Mr. Hui? Right, I'd like to reiterate once again that the government's position is that we want to get the bill enacted as soon as possible so that employees will benefit. The purpose of the whole bill is to benefit the employees. We certainly have no intention to delay the passage of this bill. Well, in that case, you will not, but still you're not willing to give an undertaking regarding the timetable proposed by the chairman. We want to do it as soon as possible, but we cannot set a deadline for the LAB to arrive at a consensus. But the LAB has already arrived at a consensus, which is 3 days, except that we some of us have different views. Someone suggests 5 days, others in 7 days. I'm sure that those representing the unions will propose 5 days. If you say you still need to listen to the LAB, then you are stalling. I think we should still try our best to stick to the timetable of July the 8th, that is, we finish the scrutiny of the bill. As to how the administration deal with amendments moved by members or policy proposals, I think the ball is in the government's court and they will need to deal with it as soon as possible. And I think this is a consensus of the members of this Bills Committee. So I'll now give time for Ms. Chang. It's your 4th round and you have 2 minutes. Please do not repeat the question you asked earlier already. I just made a suggestion that we should accept 3 days first, because 1 year later there will be a review of the ordinance. And if members at the time think that 3 days are not enough and you propose, more days for paternity leave, then certainly they can do that. But at least we shouldn't affect those people who are about to become fathers this year. We shouldn't, prevent them from benefit from the paternity leave. So I wonder whether the government can consult the LAB this week and find out what its reaction is. If the LAB is standing firm then let's not get things too complicated. Otherwise, I think we should do it expeditiously. Otherwise, you could be chairing this committee for 2 years and still come to nowhere. Well, as the chairman said, we want to complete the scrutiny of the bill by the 8th of July. At which time we hope we'll be able to get good understanding of the amendments to be moved by members, and then if we need to conduct consultation, we will do so as soon as possible. Mr. Chen Shih-Chun, 3 minutes. I'd like to follow up my earlier question. There are two opportunities for us to move amendments. First of all, this committee can move an amendment, and after the resumption of the second debate, any member of this council can move an amendment. And if you take that back to the LAB, that is the 5-day or 7-day option. But if someone want to delay this and propose an even longer period of paternity leave, how are you going to deal with that when you go back to the LAB? Or would you evaluate the possibility of that such an amendment being accepted by the LAB? And if there's no consensus, you will still come back and resume the second reading and see whether or not it's going to be carried or not. And would you ask members to withdraw the amendments before you come back to us? Even if after we've heard the views of all members, if someone propose 15 days, 7 days, a month, we certainly relate all such views to the LAB so that the LAB can arrive at a consensus. And if it could, then we will resume the second reading. What happens if the LAB cannot arrive at a consensus? Well, in that case, we will still stick to the original bill. If there's no consensus at all, I can't recall whether or not this has happened. I mean, even if you may not have a consensus on the broad major issues, you may still have some amendments on the minor issues, in which case the government can move an amendment. For example, for the minimum wage ordinance, the government, having heard the views of the Bills Committee, consulted LB, after which we move some amendments. But it's not always the case that the government accept all the amendments moved by the Bills Committee, because sometimes LB will not be able to come to a consensus. Any follow-up, Mr. Chen? Well, I was just citing examples. I'm not proposing 14 days or a month. Do we have any other colleagues who would like to ask questions? I'll allow you sufficient time, but please do not repeat what you've already covered. If not, then I'd like to go back to the clause-by-clause scrutiny. At the next meeting on the 8th of July, members, if you wish to move an amendment, please submit them before that. So back to the clause-by-clause, we already completed Clause 1.
So, Mr. Hui, we will start with Clause 2. So you can read out the Chinese version, and then we'll at the same time also look at the English version. I invite my colleague, Ms. Chang, to take members through Part 2 now. Yes, Chairman, Part 2, Amendments to Employment Ordinance. And so we have 3 to 6, 3, paternity leave, and then we have amendments to the employment ordinance in relation to paternity leave and paternity leave pay. So that's Clause 2. Yes, can we move on to Clause 3? Section 2 of the Employment Ordinance, Interpretation. We have the definitions. And may I refer to the marked up copy, page 4 of the Chinese version, page 6 of the English version. And Paternity leave means the paternity leave provided for in Part 3A. Paternity leave pay means payable in respect of paternity leave. Yes, thank you, Ms. Chang. I think you can continue. And then Section 22B, after Section 22B of the Employment Ordinance, to add bracket BA. And then after Section 2AB, we'll add BA in relation to any paternity leave pay under Part 3A. If paternity leave is taken in a period of consecutive days, the date on which that period begins, or in any other case, the date on which paternity leave is taken. And this is because paternity leave can be taken in a period of consecutive days or on isolated days. And there is also the amendment to the English version. And then we can move on to clause 4. Please pause, Ms. Chang. Legal advisor, please. Anything on clause 3? Thank you, Chairman. On the 24th of June, the Legal Services Division wrote the administration on drafting aspects of the bill. This is paper CB 219111314 bracket 01. Concerning clause 3, paternity leave pay, we have this observation, and that is the definition does not refer to how paternity leave pay is fixed. But then looking at the employment ordinance, there are signpost definitions for annual leave pay, holiday pay, LSP, and so on and so forth. In other words, how these are calculated. So we hope that the administration can give an explanation here. Yes, thank you. I think Mr. Lam from the DOJ can explain. Yes, Chairman. We've received the letter from the legal advisor. The definition of paternity leave pay is clear. And the relationship between paternity leave and paternity leave pay is clear. And so we don't think there is a need to provide a definition, a signpost definition. There is a definition for paternity leave, and so the meaning of paternity leave pay is clear. And now, for example, sickness allowance refers to the allowance referred to in Section 33, but then the allowance doesn't say where it arises from. But then for paternity leave pay, it says it is payable in respect of paternity leave, and so we don't think there is a need for a reference to the relevant provision. All right, paternity leave pay means pay payable in respect of paternity leave.
其實係咪講緊係根據翻個 employment ordinance statutory？
So is it statutory pay under the employment ordinance? I don't think that's really very clear, and that's why our legal advisor has raised this point. Can you please explain? No, because under Part 3A, there is a definition for paternity pay. So the paternity leave referred to here is statutory paternity leave. But I'm talking about paternity leave pay and not paternity leave. Yes, paternity leave is defined in 3A. That period is called paternity leave. But then there is no definition for paternity leave pay. It merely says payable in respect of paternity leave. But that may include extra pay given by the employer to the employee. So what do you mean by payable in respect of paternity leave? Are you talking about the 4/5? So why is it that it is worded in this manner? Chairman, payable in respect of paternity leave. Now, this is because the employee has taken paternity leave and he is entitled to the paternity leave pay. Are you talking about entitlement under the contract or entitlement under the amendment ordinance or the bill? The entitlement arises or comes from 15G. So let's look at 15G. Let's have a cross-reference to 15G. Legal advisor, what do you think? I think there should be a cross-reference to 15G. Mr. Lee Chuk Yan, is it that you have a question? And also 15H, the rate. I think 15H is the definition. What is paternity leave pay? The 4/5 pay. Yes, you may say that the rate is 4/5. So I think that what's in 15H is the definition. So should there be a cross-reference to 15H? Because for holiday pay, means the pay under Section 40. So for holiday pay, there is a reference to Section 40. So how come, from a drafting point of view, we don't have a reference to 15H for paternity leave pay? That would be neater and tidier. Yes, holiday pay, there is the cross-reference. So why is it that we don't have a cross-reference to 15H for paternity leave pay? In fact, this is for the easy reference of the lawyers. Apart from holiday pay, concerning Section 2 interpretation, for example, maternity leave pay means maternity leave pay payable under Section 14. So that's clear. So can you explain why, in this case, in the case of paternity leave pay, we don't have the cross-reference? I think this is a drafting point. Yes, Chairman. Concerning holiday pay, in fact, two sections are involved. So for Section 33, sickness allowance, in fact, Section 24 also comes in. For example, the calculation formula and so on and so forth. So Section 33 states what the relevant provisions are in relation to the sickness allowance. But then for paternity leave pay, we don't want too many subsections in each section. And so concerning the calculation formula, the exemptions, then we may have to spell them out, not only in 15G and 15H, but also in the other provisions, and as a result, there will be incompatibility with the provisions following. For example, to B, BA will be added. It says any paternity leave pay under Part 3A. So should it be any paternity leave pay under Part 3A or any paternity leave pay under a certain section? So we want to avoid inconsistencies. So what is paternity leave pay? That's pay payable in respect of paternity leave. So this is, you can say, a term in abbreviated form. Yes, perhaps you can consider the drafting, the style. Now, because in this same ordinance, we have different drafting styles. And as a result, lawyers and employers find this ordinance not really very readable. So I think in the resumption of second reading debate, I will talk about my overall impression of the ordinance. Because I think this ordinance is very difficult to understand. There are contradictions. So perhaps next time on the 8th of July, you can tell us whether you wish to propose any improvement to the definition of paternity leave pay. So I think we can move on now. Yes, thank you. Chairman, Clause 4. Amending Section 7 of the Employment Ordinance, termination of contract by payment in lieu of notice. And in fact, that's page 6 of the Chinese version marked up copy and page 8 of the English marked up copy. 7.1a, adding a day of paternity leave after a day of adding a day of paternity leave after a day of maternity leave. And then 7.1 capital B small letter A1 again. We add the reference to paternity leave. All right, let's please give me some time to take a look at this.
Do members have any questions? If not, we move on to the next section. Section 5, amend Section 11A, interpretation. In Section 11, capital A2, bracket A, we add maternity leave. Add a day of paternity leave. Under 11A, 4A, bracket I, again we add paternity leave after maternity leave. It's the same amendment applies for the English version. All right. If there are no questions, we'll move on to the next one. Section 6. We add Part 3A to Part 3. Let's start with 15D. That is. Employees, male employees entitled to paternity leave in respect of the birth of a child, subject to certain conditions, and these conditions are prescribed under A2. That is, he will need to be the child's father, that he has been employed under a continuous contract immediately before taking leave, and has served prior notice to the employer. The bill also stipulates that the employee can provide for the period of paternity leave. It could be that is begins 4 days before the expected date of the delivery of the child and ends 10 weeks from and inclusive of the actual date of the delivery of the child. Ms. Cheng and Ms. 去 for 15D1 15D1B he has been employed under a continuous contract immediately before taking leave. So in other words, in this continuous contract, no matter how many days he has served, so long as it's a continuous contract, then the employee will be entitled to the paternity leave. Is that your intention? Chairman, what this means is that at the time when he takes his leave, or prior to his taking paternity leave, he would already satisfy the requirement regarding continuous contract. So this is the condition for taking leave. But at the time he served notification, he doesn't. So before he takes his leave, he would have served notification. At that time, he wouldn't need to satisfy the requirement for a continuous contract. No, there's no such requirement in the bill. Mr. Lee Cheuk-yan, let me clarify this point. This could be no pay leave. The question is that if you look at the entire bill, you have a separate provision later. That is, if you want to have the entitlement for paternity leave pay, you will need to have worked continuously for 40 weeks. But here it doesn't mean, it's not about the pay, the money, but rather so long as the employee has a continuous contract, then he can take leave, but there is no pay. So I don't think that it doesn't have any meaning. It's like taking a no-pay leave. The difference is that if the employee, wants to take such a leave, the employer cannot refuse, but then the employee will not get any pay. Is that the case? 15E1D will determine whether or not the employee is entitled to leave. Whether or not he is entitled to the pay will depend on whether or not he satisfies the provision regarding paternity leave pay. But here we haven't come to the point as to whether or not he has he will have the paternity leave pay. So it seems, Chairman. But if someone has to go through all these complications to take the leave and there's no pay, it seems rather a futile exercise. So I don't know. You say the employee has the entitlement to take leave, but in practice, how does it really benefit the employee here? Because eventually he will not be paid. Whether or not he is paid will depend whether or not he satisfies the contract requirements. It doesn't mean that he will not be paid. Here it just establishes that he has whether or not he has the right to take leave. If he has served conditions for 40 weeks, then if he served the proper documents, then he will also be entitled to the paternity leave pay. Ms. Chan, you may go on. Subsection 4, that is, multiple births in one pregnancy are taken to be one confinement. Subsection 5 applies to a child born on or after the date on which the Employment Amendment Ordinance comes into operation. Please go on. There's the same reference in the English version. Next, we come to 15. Any questions regarding 15D? I think we seem to be moving very fast. No. I have a question regarding 15D 2B. If we were to move an amendment, should we move the amendment at this stage while doing the clause by clause? There is no more than 3 days of paternity leave. Regarding amendment, Ms. Wong may consider moving the amendments at one go after we finish the clause by clause. in our early discussion, the administration said that they will take note of members' views in the course of the clause by clause and also see whether members will be moving any amendments before the 8th of July. Ms. Wong, if you wish to move an amendment yourself, you may submit them for discussion before the 8th of July. If you wish to move an amendment in respect of the bill, I hope that you can submit them before the 8th of July. Of course, that's not the only window through which you can submit an amendment. When the government submit the bill for resumption second rebate, you can still move an amendment at that stage. So that it would be a choice for yourself. That is, if you so you have time, before the 8th of July. If at that time we already have completed clause by clause, because you've already come to section 15. So no, there's no problem. We don't need to go back. We will simply be discussing the amendment you'll be moving. We don't need to go back and repeat the whole clause by clause again. Clause by clause means that we've scrutinized each and every provision in the bill. The discussion regarding your amendment will be a separate discussion. So the clause by clause is simply for the administration to explain its position in respect of all the it doesn't mean that we accept the provisions, except it just means that we've gone through the different provisions so the members can consider them and decide whether or not you wish to move an amendment. But that is the clause by clause procedure is a stage that we must go through. Thank you, Chairman, for clarifying that. So we're now during the clause by clause stage. So we do not need to move an amendment when we identify any problems with any particular section of the bill. So I hope members will put on record that I will be moving an amendment in respect of 15E2B, that is no more than 3 days of paternity leave. Legal Advisor. Thank you, Chairman. Regarding section 15D, I think could the government confirm that this also would apply to foster children? The bill doesn't, cover the case of foster children. Of course, it is our policy that we do not include adopted children. The purpose of paternity leave is to enable the father of the newborn to look after the newborn and the mother as well. But we do not have, well, in the case of adoption, the father doesn't need to look after his wife who's just given birth, and secondly, and the period, I think the adoption will take place after the child has been born for a long time. All right? We may now move on to 15G. Section 15G is about notification requirements relating to paternity leave. And an employee who intends to take paternity leave in respect of the birth of a child should notify the employer of his intention at least 3 months before the expected date of delivery of the child, and of each intended date of his leave at least 2 days before that date. And subsection B, if he does not notify the employer in accordance with paragraph A1, notify the employer of each intended date of his leave at least 5 days before that date, then so I'd like to ask what is the logic here? First of all, the employee would need to notify the employer 3 months in advance. In Roman 2, you said that that he will need to inform the employer 2 days before the intended date of his leave. And in B, if he cannot serve a 3-month notice, then he still has 5 days. So does it mean that the employee should at least serve 2 days notice? Why do you require the employee to serve so many different types of notice? And for B, why is it 5 days and not 2? So for 15E1, could you explain the logic behind this for us? Under 15E1, that is at least 3 months before the expected date of the delivery of the child. I think this is the consensus of the LAB. Some employer representatives were concerned that that we need to consider the operational needs of the company, so that the employer would need to know well in advance when the employee is going to take his paternity leave, so that he can, come up with the arrangements accordingly. But if the employee, so it will also make it convenient for the employee to arrange for replacement or substitute. So, and then the employer will have to inform the employer on which day he intends to take the paternity leave at least 2 days in advance. As for subsection B, it will cater for exceptional circumstances. Normally, the employee would know well in advance when the child is expected to be born. But there might be situations during which before the expected date of delivery, the child is already born already, in which case the employee may not have enough time to notify the employer. And in order to cater for such a scenario, we would still allow the employee to take paternity leave. But in this case, he would need to serve a longer period notice, which is 5 days. Mr. Lee Cheuk-Yen? But sometimes you cannot assume that all employees know what his rights are or be familiar with what the bill says. Of course, the employee will know the expected date of delivery or birth. Let's say the employees failed to serve a notice 3 months in advance. He only remembered to serve the notice 2 days in advance. Then what's going to happen? Does that mean that he will then not be entitled to his paternity leave? And secondly, what happens in case there is premature birth? For B, do you mean that you will still allow him for 5 days? Or so? Under what circumstances can B be invoked? B said that the employee doesn't notify the employer, then because it's forgotten, then he can serve 5 days notice. So basically, we're still talking about those 3 days here. Ms. Chang. Thank you, Mr. Lee. Subsection B would cater to the scenario where the employee can serve the notice pursuant to subsection 1. What happens if he forgets? Then he won't be. He will lose his entitlement. If nothing exceptional happens, then he must serve a 3-month notice. And B will cater to exceptional circumstances such as premature birth. We will not prescribe the reasons as to when. So long as if he failed to serve a 3-month notice and if he needs to take the paternity leave, then before he takes the paternity leave, he should notify the employer 5 days in advance. We will not deprive his entitlement to take paternity leave. So long as he forget to serve a 3-month notice, then it would be 5 days, right? If you serve a 3-month notice, it's 2 days. Well, it's okay, but then you're making it so complicated. And the employee will need to remember all these requirements. Right. Let's go on to the next one.
第二款個
Yes, thank you. It is said that the employer can require the employee to produce certain documents, and there will have to be a written statement. The employee is the father, and then the statement must also contain the name of the mother, and also if the baby has been born, the date on which the baby was born. All right, let's move on. 15F. Ms. Chang. Paternity leave is in addition to rest days, holidays, and annual leave to which an employee is entitled under this ordinance. That's 15F1.
an annual leave to which an employee is entitled under this ordinance 嘅。咁
Yes, please continue. Then 2. If an employee has, in compliance with the requirement in Section 15E1, notified the employer that intends to take paternity leave on a particular day, and that day falls on a rest day or holiday, or falls within a period of annual leave, he is entitled to take the leave on the day immediately after the rest day, holiday, or period of annual leave. And the employee is entitled to take leave on the day mentioned in subsection 2, even if that day falls on a day after the 10-week period mentioned in section 15D3B. In other words, even if the day falls on a day after the 10-week period, the employee can still take the paternity leave on that day. Ms. Helena Wong. Yes, I understand that you want the employee to notify the employer as early as possible as to when he intends to take paternity leave. But then concerning 15E1A, we are on 15F. Is it that you still have a question concerning 15E1A? That it says at least 3 months notice, and then at least 2 days before that date of each intended date of his leave. So there are these periods: 3 months, 2 days, 5 days. But what if the employee cannot comply with such notice periods? Is it that he won't get any pay for his paternity leave? Now, of course, will not prohibit the employer from waiving the leave to be given by the employee. Now, in fact, when an employee wants to take leave, he can, of course, have some discussions on with the employer on the leave. So he said that he can't take paternity leave if he hasn't indicated his intention at least 3 months in advance. Ms. Chang. Now, if the employee has not notified the employer of his intention at least 3 months before the expected date of the delivery of the child, then under B, he can notify the employer of each intended date of his leave at least 5 days before that date. So what is the meaning of specifying 3 months in A1. In other words, if the employee can't give his intent or notify the employer of his intention at least 3 months before the expected date of the delivery of the child, he will not be punished. For example, he will not be denied paternity leave pay. His paternity leave period will not be cut. Is that right, Ms. Chang? No, there was a consensus reached in the LAB between employers and employees. So under this consensus, sufficient notice should be given to employers so that employers can make the necessary arrangements. But in certain cases, the employees may not be able to give the 3 months notice. But they will not be denied their paternity leave. But then at the same time, we need to consider the need for employers to make necessary arrangements. And so we would. If he can't give the 3 months notice, then he needs to notify the employer at least 5 days before the date. So in fact, I think 5 days is the real deadline. So the 3 months is rather meaningless. The 3 months is for the employer to make adequate preparations. Just to allow the employers to make preparations, especially operators of SMEs. And that's so. My understanding is that there is no intention to punish the employee for failing to give sufficient notice. Is that right, Ms. Chang? Yes. But then the provisions must be enforceable, right? But then I think the 3 months really represents goodwill on the part of the employee to give a friendly reminder to the employer. But in fact, this is not mandatory. And in fact, the employee only needs to give 5 days notice. Now, if he indicates his intention 3 months before the expected date of the delivery of the child, then he can take his paternity leave at least 2 days. By giving at least 2 days notice. But then if he hasn't given the 3 months notice, then he needs to give at least 5 days notice. So if he has indicated his intention 3 months ago or 3 months before, then he only needs to give 2 days notice. So this represents a balance between the employer's rights and the employee's rights. But then, as you know, because the wife may give birth and any time, and the employee may not be able to give even 2 days notice. So I think if the employee can prove that his wife is giving birth, and so as long as he has given the 3 months notice, I don't think the 2 days notice is really necessary. Is it that we want to encourage all pregnant women to undergo cesarean operations? And in fact, for those who undergo cesarean operations, in fact, the recovery takes more than 3 days. So I think this the need to give 2 days notice is unreasonable. Mr. Hui, this is again an arrangement to try to balance the interests of employers and those of employees. Now, in fact, employees from time to time do have to take urgent leave. And of course, for the employee who will become father. This is of course something that's happy, and I don't think the employer will insist on the 2-day notice. And I believe in general, the employer will not disallow the employee from taking paternity leave. But if the employee has served adequate notice, then the employer cannot refuse to give permission, because for other types of leave, annual leave, the employer can refrain from giving approval. But here for paternity leave, so long as sufficient notice has been given, the employer cannot refrain from approving the leave or granting the leave. Chairman, what I'm trying to say is that you require the employee to indicate to the employer his intention at least 3 months before the expected date of delivery of the child. Then I think the 2-day notice requirement should be dispensed with. Now, because the employee has already notified the employer of his intention at least 3 months before the expected date of delivery of the child, and so the 2 days notice is not reasonable. Now, because what if the delivery is earlier than expected, earlier than the delivery date? Please, we don't know when the baby chooses to come to this world, and we can't treat pregnant women as if they were machines, and that we could control the time of or date of delivery. Yes, Ms. Look. Chairman, we need to take into account difficulties faced by operators of SMEs, but of course we also have to take into account the uncertainties surrounding pregnancy and delivery, and also perhaps we can look at A1, and that is the employee only needs to notify the employer of his intention to take paternity leave around a certain time. And the employee also has a lot of flexibility in deciding when to take the paternity leave during the 4 weeks before the expected delivery date, or the 10 weeks after the expected delivery date. Now, SMEs do not want employees to take leave. They want their employees to go to work every day. Now, we want a family-friendly employment environment. The wife is going to give birth to a child. That's the most important thing to the father.
Since not all the employers are unscrupulous, but if you put it in the bill, it will be legally binding. The employer may say, although you've served me a 3-month notice, but now you've not given me a 2-day notice, then I have the right not to grant you paternity leave because I haven't found a substitute to replace you yet. So you're creating a labor dispute here, even though not all employers will be like this. But if you have an employer try to make things difficult, and he will say, well, this is what the law says, and then the culprits will be councillors like ourselves because we agree to this proposal of yours. I'm telling you that this is not, humanistic enough. I mean, the employer will try his best to serve you a 3-month notice. The male employee would like to witness the birth of his child. He may want to go into the delivery room. And the employer said, no, you haven't given me a 2-month notice. I think the law in this case would be very, very inhuman. Unless we assume all women will give birth by cesarean operation. But that's not the case. We shouldn't even encourage people to take cesarean operations. Mr. Hui. Please do not always cite the example of SMEs. I think for all labor legislations, all the requirements we need to balance the interests of employers and employees. We can't just focus on the interests of one party. So the employer serves a 3-month notice, only a 2-day notice is required. If no 30-day notice is served, then a 5-day notice beforehand would be required. So this is a provision that we propose after taking into consideration the interests of both parties. Well, Ms. Wong, if you want to persist, then I think you should instead move an amendment. I don't think you need to explain the CSA you intend to serve. Of course, I will welcome you to move this now, but we would welcome you. So, but it would be better if you could, submit your CSA in writing so that we can debate them. So we haven't. So if we finish with 15F, we may now move on to 15G. Thank you. 15G is about entitlement to paternity leave pay. An employee is entitled to pay at the rate specified in Section 15H in respect of each day on which he has taken paternity leave if he has been employed under a continuous contract for a period of not less than 40 weeks immediately before that day, and that he has complied with all the requirements in Section 15I or J. 15I refers to children born in Hong Kong and the documents that is required to submit it. 15J is about children born outside of Hong Kong and the documents that would need to be submitted. All right, please move on to 15H. 15H is about the rate of paternity leave pay and how it's calculated. 15H is similar to provisions governing the calculation of other statutory entitlements. The principle is that we take into consideration the average wage of the employee for the past 12 months in calculating his entitlement. In calculating the paternity leave, we will include a sum of money paid by an employee in respect of any of the following days. A day of paternity leave, a rest day, sickness day, holiday, or a day of annual leave taken by the employee, a day of leave taken by the employee with the agreements of the employer, normal working day on which the employee is not provided with work by the employer, and also a day of absence from work of the employee due to temporary incapacity and so on. So that the average wage of the employee will not be lowered. If you allow me some time to go through this first.
請你繼續啊嚇，唔該。
Please go on. Chairman, I'm now on to 15I. Documents requiring documentary requirements relating to paternity leave pay for birth in Hong Kong. The employee will need to provide the birth certificate of the child, which is bearing the name of the employer who is the father. And subsection 2, that is, if the child is born dead or if the child dies after birth and no birth certificate has been issued in respect of the child, then the employer must provide to the employee must submit to the employer a medical certificate proving that a baby has been born. And if the employer so requires, the employee will need to sign a written statement stating that he is the father of the child delivered by the woman named in the medical certificate, and that the child is born dead or dies after birth, whichever is appropriate. Please wait. So under 15I subsection 2, the father would still be entitled to paternity leave even though the child is born dead, yes, or dies after birth. So even if there is no birth certificate, if there is a medical certificate proving that the child has been born, the employee will still be entitled to paternity leave. Or rather, is entitled to paternity leave pay. 15I 2 bracket B. The written statement signed by the employee, should he simply, write a note and he doesn't need to sign a formal legal document? Thank you, Chairman. We've taken into consideration that employers could be of different sizes and scales, and the need for harmonious employer-employee relationship. Therefore, we've not prescribed a particular format for this statement to be made, so long as the employee can say in the written statement what is required under subsection under bracket 1 and 2. All right, please move on to subsection 3 now. 15I bracket 3. Thank you. For 15I bracket 3, this is in regard of the medical certificate. That is, a medical certificate must certify the delivery of a child and it must be issued by a registered doctor or a midwife. 15I 4. I4 is about the documents required under this section that must be provided to the employer. That is, within 12 months after the first day on which the employee takes the paternity leave, or if the employee has ceased to be employed by the employer within the period mentioned in paragraph A, or within 6 months after the cessation, whichever period expires first. Any questions? 15J then. Thank you. 15J, documentary requirements relating to a paternity leave pay for births outside Hong Kong. 15J bracket 1, an employee who takes paternity leave in respect of the birth of a child in a place outside Hong Kong must provide the employer with the birth certificate of the child that is issued by the authorities of the place concerned, on which the employee's name is entered as the child's father. And bracket B, if the authorities do not issue such birth certificates, then any other document issued by the authorities that could reasonably be taken as proof that the employee is the child's father. The English version is the same. The authorities, is there a definition of the authorities of the place? Is there any explanation as to what they are? 15J1A, the authorities of the place. How do you interpret that? I'll ask Ms. Look to explain. Thank you. Here we had deliberately adopted a lax approach in the drafting because we note that we may need to deal with situations in different parts of the world. For example, in the mainland of China, such documents are issued by the hygiene authorities. It's not like Hong Kong, which is issued by the birth and death registry. So we would like to adopt a more lax approach for the convenience of employers and employees. So the principle here is that if there is an authority, the principle is that the document should be issued by the authorities. I think some members have raised questions regarding 15J. They hope that you could issue some guidelines here. All right, please move on to subsection 2, 15J2. Thank you. 15J2, that is about a scenario where if the child is born dead or dies after birth, and neither the birth certificate nor document mentioned at that subsection is available, then the employee must provide the employer with a medical certificate or any other document issued by the authorities that could reasonably be taken as proof of the delivery of the child. And same for children born in Hong Kong. If the employer so requires, the employee will need to sign a written statement stating that he is the father of the child delivered by a woman named in the medical certificate, and that the child is born dead or dies after birth, whichever is appropriate. Bracket 3. The documents required under this section must be provided to the employer. A. Within 12 months after the first day on which the employee takes the paternity leave, or if the employee has ceased to be employed by the employer, within the period mentioned in paragraph A, or within 6 months after the cessation, whichever period expires first. I think we can stop our clause by clause here. Our next meeting is scheduled for the 8th of July at 10:45. At our next meeting, we will continue with the scrutiny of the other provisions, and if there's time left, we will discuss CSAs that members may wish to discuss. So it's 10:45 on July the 8th. So thank you very much. CSA. Also, other than dealing with the CSA, the administration would need to provide written responses to the questions we've raised. You need to give us a response in respect of two issues. So at the next meeting, we'll also be discussing those two papers.